strictly brand new lawyers. But that's not the situation. That is not the situation here at all. How are you, David? I recognize many of you. So let me begin with an opinion. All right, well, first of all, let me begin with the materials that you have in front of you. Okay, we've got 3 topics that we're going to address in the Porsche of life in the next 45 minutes to 1 hour. They are forfeiture, appealable orders, when to appeal, and ineffective assistance of counsel. I'm going to leave ineffective assistance of counsel for last. Why? Because I want you to leave it in your heads for last. Okay, I don't want anyone, freaking out. Oh my God, ineffective assistance of counsel. Oh my God, if I make a mistake, what's going to happen? First of all, I'll reassure you before even going into that topic of 2 things. One, most mistakes are correctable in dependency court. And one of the greatest mechanisms for correction of mistakes, of course, is the 388 petition. Secondly, no appellate attorney, that means no panel attorney that takes appointments in the 2nd District Court of Appeal through the California Appellate Project in Los Angeles, can file a brief raising ineffective assistance of trial counsel or a petition for writ of habeas corpus raising ineffective assistance of trial counsel without basically my permission, just because I'm it right now. So that means fundamentally Cap LA must review to make sure that we really have a solid claim of ineffective assistance of counsel and really that there's no way out. Third, no claim of ineffective assistance of counsel should ever be made without communication between appellate counsel and you. So if you are ever in we did have a situation, I brought this to the attention of Ellen Bacon, who's actually leaving you folks and coming on to the California Appellate Project, but about I think maybe 3-4 weeks ago, by golly, I picked up a brief, and believe me, I did not use the words by golly when I picked up that brief, and I read it, and voila, ineffective assistance of trial counsel was raised. It had not been pre-authorized, so immediate contact was made with appellate counsel, some appropriate investigation was done, and bottom line is that brief was stricken. So that's what's supposed to happen. We have about, I think certainly in 2016 we had over 1,200 appeals out of LA County and the Tri-County courts, which are Ventura, Santa Barbara, and San Luis Obispo. At least 90% of those were LA County appeals. So there are situations where things are missed. I'm letting you know. You may see something before I see something. You know what the procedure is to be. You need to give me a call at the California Appellate Project. So today, actually it was published yesterday, but it's printed in the Daily Appellate Report today, is a case in re AK. It's not in your materials because it was just printed yesterday. Okay, take a look at your table of contents. You'll see what I provided you with, again, is case law on forfeiture, when to file a notice of an appeal, what's an appealable order, and representation, parental right to adequate representation. Anyway, so what happened in AK is a really great working example of the topics of when to file a notice of appeal and forfeiture. So, all right, you come into onto the detention calendar and the detention, I suppose, / arraignment calendar, and the first item of business, of course, is perhaps the children have already been taken into protective custody pursuant to a warrant, which is required. There is actually the Fourth Amendment does apply in dependency cases. It took a long time to get to that realization, but by golly, the Ninth Circuit did, and in Wallace, anyway, that's W-A-L-L-I-S. Anyway, you come onto the detention calendar, and you're appointed, and the first issue is, ooh, wow, is a juvenile court now going to detain? Can I oppose detention? So, let's say you're losing on that point, and chances are, if the children have already been taken into custody, protective custody pursuant to a warrant, chances are you are going to be losing on the detention issue. So what's the next thought that should be popping into your head as a lawyer if you're not able to secure placement of the child with your client? What else do you want to be thinking about? Ready? Relative placement. You want to be thinking about Section 309, okay? And you want to be thinking about Section 361.3. Section 309, I don't know, E3 or something says, hey, within 30 days after that child is removed from the parent, statute doesn't define the term removal. You know, there's protective custody, there's detention, there's removal. Those are three distinct terms of legal art. But anyway, 30 days after the kid is removed, social worker within that 30 days has to be investigating relative placement. You may not be able to save, the child's placement with your client, his or her parent. Maybe you can save the child and the family by retaining the child in the custody of a relative, right? So that's a very significant objective that you'll want to have in mind every time you've got a client whose child is detained. So what happened in AK? That didn't happen. There wasn't any consideration of relative placement at detention, okay? There wasn't any consideration of relative placement at disposition. After the petition is sustained, of course, we get to disposition. It's time to consider, okay, we're at detention of the child. Now it's time to consider removal of the child. Of course, we know that that's held to a higher standard of clear and convincing evidence. Okay, in AK, again, not at detention, not at adjudication, at disposition, not at the 6-month review hearing, not at the 12-month review hearing. Okay, nobody's thinking relative placement. So what happens though, at the 2-6 hearing, trial counsel says, hey, what about placement with the paternal grandmother? Paternal grandmother, raised her hand, surfaced about a month ago or so. What about it? What can we do here? So trial counsel at least gives voice to the paternal grandmother's quest for relative placement, and at least puts the issue on the table. But that's it. That's it. So we get an appeal. By the way, this is not out of the 2nd district, out of your courtroom. This, I think, is a 3rd appellate district opinion. But anyway, so on appeal, appellate counsel, separate counsel is appointed for the mother and the father. Appellate counsel furiously writes a brief raising relative placement. Hey, here we were at the 2-6 hearing. Trial counsel raised relative placement, and nothing happened. Not only did nothing happen at the 2-6 hearing, but gee, nothing happened when it should have happened back at detention. I mean, the record doesn't show that the social worker within the first 30 days after the child's removal investigated placement with relatives. Well, the reviewing court, as it properly should have, I'm going to leave standing aside. That's kind of a complicated, not that it's too complex for you by any stretch of the imagination, but we're just not going to go down there right now on that path. But anyway, the reviewing court knocks out this appeal on forfeiture grounds. It says, wait a minute here. All right, wait a minute here. Relative placement, the first opportunity, to address relative placement is at the point of initial detention. Somebody should be saying something about it. Nobody filed an appeal from the judgment. No one from the 6, 12, 18-month review hearing. Boom, here we are at the 2-6 hearing, and now it's raised. Sorry, folks, this is forfeited. Forfeited. Forfeiture. Let me tell you, I think I have, I mean, I literally have volumes of training material, and forfeiture, case law on forfeiture and on the Indian Child Welfare Act occupies more of my materials than any other area of law. Isn't that astounding? That really is astounding. Anyway, if I had to really, the case law that you have on forfeiture in these materials is only through 2010 or 11. I had to stop because, I mean, it just would have been too voluminous. You know, everybody would have walked out, I'm sure, if they thought, oh my God, this is what I have to read on forfeiture. So anyway, you've only got a portion of my case law, or my summaries, excuse me, of case law on forfeiture. So anyway, relative placement issue is just completely blown by trial counsel. But I want to stress one little nuance of forfeiture that was addressed in AK. And that is the principle that in addition to making an objection, all right, you've got to press for a ruling on that objection. You don't, we're out of court. So going back to AK, trial counsel shows up at the 2-6 hearing and says, hey, you know, a month or so ago, paternal grandmother raised her hand and said, hey, what about me? You know, I'm interested in a little Joey. Trial counsel, you know, Your Honor, so we need to consider relative placement here. Go through the whole gosh darn 2-6 hearing. The trial counsel doesn't press for a ruling on the relative placement issue. It's implicitly denied, but that's a real forfeiture problem. So for heaven's sakes, make sure that when you make an objection, you follow up with, Your Honor, excuse me, I need a ruling on that. Specific objections are extremely important. You know, I read a lot of records. I read way too many records. You know, I read all of your records. They're fascinating. They truly are. Well, actually, that's really not true. I mean, actually, some of them are. You know, it's actually not because of you as trial counsel at all. Actually, trial counsel is probably the most entertaining party in the courtroom. It's really where we get kind of bogged down and bored is oh my God, how many domestic violence and drug abuse use cases, you know, can you read? You know, with I mean, it's the same old story. But anyway, I certainly do appreciate, you know, the creativity and ingenuity of trial counsel in trying to bring something new to these very standard predicaments of the parents here in dependency court. I mean, in the line of work we do, it's as though everybody is doing drugs and beating up on one another, and maybe they are. I mean, just not all of us get caught. But anyway, we need a specific objection, and one of the great little cases on this that I'm going to cite you to. I'm going to have you open to your, because this might be the only time you open your material, so at least you won't feel so guilty tonight. You know, well, at least I opened it once. Yeah, I've kind of looked at it. So anyway, it's on page 45. Yeah.
Pages were changed a little bit to shrink the.
All pages were changed a little bit.
Given the title.
So yeah, so it's In Re EA. Don't worry about it. In Re EA, 2012.
It's probably a few pages up. The materials were shrunk a little bit. It was like 70, I think.
Yeah. So yeah, right. Sorry. See, I was worried about that. I was so glad when he didn't reject me last Friday.
No.
I was like, woo, thank God.
I'm like, you have to just figure it out.
Page 40. Thank you.
Thanks, Jen.
Thank you. So just for the heck of it, what's your name? What's your name? Just so I know. You know.
Jasmine Durr.
Jasmine, that's who you are. Jasmine Durr, D-O-E-O-L. I'm Stephanie Miller. Nice to meet you. You know, anyway, that's kind of fun, though. You know, we could say, so now you know who I am. It's kind of like fair play, you know. I mean, I mean, I should be able to know who you are. I mean, some of you guys I know just because unfortunately, we work together, fortunately or unfortunately, we've worked together for so many years. Who else have we got? Anyway, okay, so, in re EA, general objections, forget it. You might as well just keep your mouth shut. You might as well not waste your breath, all right? General objections are insufficient to preserve issues for review. The objection must state the ground or grounds upon which the objection is based. No one is served by purported objections to all of the orders handed down by the court as to a parent, right? Including a suitable placement order, which do not state the grounds for the objection. Primarily, the court is not advised of the reasons that the party making the objection has for thinking that the order made or the evidence presented is erroneous or inadmissible. If the order was in fact erroneous and the court is persuaded by the reason advanced by the party, the court has the opportunity to correct the error. Otherwise, it's not fair to the trial court or to opposing appellate counsel, and we don't want appellate counsel inventing grounds for objections on appeal. They just won't hold. But anyway, one of the this is a very good example of a general objection that was unsatisfactory. Fathers, quote, fathers also objecting to the court's order that he have monitored visits only when released from his place of incarceration. All right, you've objected, but basically you always got to follow up in your head with why? Why is he objecting? Well, father is objecting because the child is being placed in the home of father's mother, and there's no reason why father can't have unmonitored visits in the home of his own mother with the child. In other words, I'm objecting on the ground that the monitoring restriction is overly broad or unnecessary, not supported by any need for child safety. A lot of oops, excuse me.
Sorry.
We'll get to that famous portion of the disposition where you don't like where I am, do you?
No, it's the
Yeah.
problem they're having is they can't hear you sometimes.
They can't hear me.
Yeah, you fade in and out, and if you sit like right about there, you're just about right.
Okay.
How about that? Guys, can you hear her now?
I'm not talking, that's why you can't hear me.
Exactly. That should do it. We should do everything. Sorry
Okay,
about that.
that's all right. Okay, all right. So, here we are, disposition. It's case plan time. And the Department of Children and Family Services has pre-prepared its proposed case plan components. And trial counsel says, I object, Your Honor. You might as well, again, not have said anything. It is totally, completely, completely, that kind of open-ended objection is worthless for purposes of appeal. That means the appellate attorney cannot write a brief challenging any aspect of the case plan. Make sense? Makes sense. Another kind of, sometimes I think understandably, as trial counsel, you are so concerned about missing the opportunity to object, for example, and heaven forbid if I be hung for being ineffective, that the word objection pops out unnecessarily. So, classic example. Adjudication of the petition allegations. Clearly put on a contest for your client. Called your client to testify, called any of the client's witness, any of the parent's witnesses to testify, you cross-examine, and at the conclusion of the evidence, Judge Zeidler sustains the petition as amended. And you say, for the record, Your Honor, I object. Don't ever do that again. Just that's one of those things. That's one of those opportunities where you could just completely keep your mouth shut, okay? You don't have to say that. Don't, you know, don't. You know, you'll be showing the bench, I'm cool, I'm confident, I know, I'll put on my contest here. I don't need to say another word to preserve appellate review, because I can tell you, Your Honor, I'm not going to say this to him, but I can tell you, Your Honor, sub silentio, that there will be an appeal of your true findings here. So anyway, when can you remain completely silent in the courtroom? On what issue? What two issues? Can anybody come up with maybe two issues on which you may remain completely silent?
Jurisdiction.
So let's take that. In other words, I believe what you're saying here is sufficiency of the evidence. You can sit next to your client at counsel table through the presentation of the department's evidence, mum, not argue anything. Court makes its findings, enters its judgment, go down to the clerk's office and file the notice of appeal. No problem. Of course, you've alienated your client greatly by sitting there saying absolutely nothing. But the key exception to the principle that you want to preserve something for appellate review, you've got to make a specific and timely objection, is sufficiency of the evidence. All right? So, and you may, if you do intend to remain silent through the petitioner's presentation of the case, you may want to inform your client in advance of your strategy, what you're doing, and how this is perfectly copacetic and on balance here, guy. Don't worry about it. Okay, but I want to use that general principle there with sufficiency of the evidence review to distinguish submissions. In many instances, you have a contested jurisdiction hearing or adjudication of the petition, but you don't present evidence for on your client. In fact, the Department of Children and Family Services submits its case on its documentary evidence, the detention report, the application for the protective custody warrant, and the jurisdiction disposition report. And you, in turn, say, submitted, Your Honor. Now, does that submission preserve for appellate review a challenge to the sufficiency of the evidence? Yes. You're cool. Absolutely. No problem. Okay, again, your client may not like you, but you will have talked to your client beforehand, all right? Problem happens when trial counsel submits on the recommendation of the social worker. You do that, you've hung yourself. You've for purposes of appellate review, it's as though the client had admitted the petition allegations. That is a concession that the opponent's position is correct. So unless you are in sync with your opponent's recommendation, and it's usually the social worker, don't submit on a social worker recommendation or on the recommendation in the social study unless you're confident with it. And if you are, don't be afraid to be confident. Don't be afraid to submit on recommendations when you're confident about the factual legal bases for them. Don't be afraid to, be in control of your case and in control of the courtroom. A second a second issue that is non-forfeitable. Anybody got an idea? Huh? That's a very good point. ICWA. Someone raised the, and what is your name by any chance, whoever said that?
Emily.
Oh, hello, Emily. How are you? Very nice to meet you. Okay, so, Indian Child Welfare Act. Well, let's face it, that's a very good point, Emily. And yes, unfortunately, you know, in order to, well, fortunately, in order to protect the Indian child, there are standing exceptions, forfeiture exceptions, even collateral attack exceptions, in order to enable review of the trial court proceedings applying the Indian Child Welfare Act. But I'm thinking of, however, let me say this, the appellate courts are weary, though, of trial counsel not being up to speed on the Indian Child Welfare Act and not being more proactive in, one, examining the notices, okay? Look, sitting down with the client, look, does the information, the relative information in this notice, does it match what you told the social worker? Is it complete? Is there a relative that's been omitted here? The appellate court has, in published opinions, pretty much pleaded with trial counsel to be more proactive in this area, because let's face it, and I'm sure you're fed up with it too, aren't you? I mean, how many remands do you have for compliance with the Indian Child Welfare Act? That's time consuming for you. Most of our children are not Indian children. Again, my materials on do you ever want a seminar on the Indian Child Welfare Act? I mean, I literally have a book on it now. But anyway, okay, so, all right, so the other one is, so nobody's coming up with it. And,
add a 2.6?
huh?
To add a 2.6?
Add a 2.6? I don't understand that.
For termination of parental rights.
For termination of parental rights, is that statement in response to my question of what is an issue that's not,
Yeah.
No, but hi, what's your name?
Oh, I'm not familiar.
Oh, I'm really, I love that last name, and every time I come across that last name, first I thought it was Matamoho. You think I'm crazy, right? But that's what you go through when you read all these records. You know, you start, oh, wow, how do I say that? Matamoto. I want to know if Ina I think I've got it right. I mean, I've really practiced it. But you have to have some sort of diversion when you're sitting there going over all of your records. And you understand, don't you? Yes, anyways, it's terrible. Oh, sorry. But anyway, okay, so I'm going to tell you, and I can tell, I know why, it's clear to me why you didn't get it. Because nobody gets it down here. Well, I don't mean that offensively. It's a Uniform Child Custody Jurisdiction and Enforcement Act. It's subject matter jurisdiction. That means anytime you got a client that's rolling through Pomona on the road back from Arizona, where they just, rented a place for a couple of weeks, but they're on the way back to California to the paternal grandmother's house because she recently sold her house, and so the parents think they can get some cash from the paternal grandmother, and so they're moving through Pomona at about 1 o'clock in the morning, and of course they don't have any operative tail lights, and they're pulled over, and the kids are filthy, and marijuana smoke fills the car. Busted! Anytime you see any of your clients moving interstate, you need to think of subject matter jurisdiction. Does this courthouse here or any courthouse in California have subject matter jurisdiction over these people? Okay? Now, fortunately, because you always forget to say anything about it, that's non-forfeitable. But it would be hugely helpful to everybody if you would say, whoa, Your Honor, we've got at least a prima facie indication here that we've got some interstate, potentially interstate jurisdiction issues here that potentially this court, Your Honor, may not have subject matter jurisdiction. Me? How could you say that to me, counsel? Of course I have subject matter jurisdiction. Anyway, it gets the ball moving. And also, this isn't just specious, this isn't just for fun. You may find that in engaging in this discussion about subject matter jurisdiction, hey, well, there's actually a relative in Arizona. And is Arizona a better forum? And anyway, you start getting the ball moving in other directions. Information starts, the information universe expands for you for purposes of preparation of your case. So, anyone want to say anything about UCCJEA? Can I walk? There's like I'm a little anxious about where I'm walking here. You know, I look like 20 months pregnant on this screen. It's most distracting. So anyway, Jesus. I mean, I know it's bad as it is, but it doesn't have to be any worse than this. Okay, so, all right. Okay, all right. So we're actually okay. When to file? Does anyone know when to file a notice of appeal? When's the first opportunity for filing a notice of appeal?
Disposition.
Right. What happens at disposition? The judgment is entered, right? Judgment is entered. Right. Okay. All right. So now this is understandable, of course, but unfortunately we get those notices of appeal that are filed before jurisdiction. It's like, wow. You know, the court made true findings on this petition, and you know, diligent trial counsel runs back to his office at lunch hour and types up a really nifty-looking notice of appeal and runs down to the clerk's office and files it. But it's premature. Okay, only the adjudication findings have been made, but the judgment hasn't been entered. Okay, so as a general rule, and it's 395, it's actually a statutory rule, 395 subdivision A1, first opportunity for appeal is from the judgment. Are there any exceptions? Yes, there are always exceptions. Just remember that. That's a good principle in life. You know, rules are made to be broken, one, and two, there are always exceptions. So, and this is a really important exception that you need to remember, because if you don't remember it, you're going to blow the opportunity for appeal. That'll scare you, right? That'll scare you. That's terrible. Oh my God. So the situation is a pre-judgment restraining order. Does it have to be a permanent restraining order? No. It can be a temporary restraining order. You need to be. And let's face it. You know, we've got these drug using, drug abusing, domestically violent parents, and you know, often you know, they come into that detention hearing and they're still engaging in fisticuffs, and certainly the Department of Children and Family Services, as a condition of leaving a child in one parent's custody, says, hey, you better go out and get a restraining order now. You better sign this now, otherwise that's it, forget it, you're not going to see your kid. You know, so we see all that. But anyway, so you've got a client against whom, you know, against whom the restraining order is issued, and boy, he or she is hot about it. Are you going to wait until judgment? Well, judgment might be more than 60 days off, one. No, if you've got a serious restraining order issue, even if that restraining order is issued in detention, get down to the clerk's office and file that notice of appeal. So that's an exception. That's a pre-judgment order, you know, issuing a restraining order. Another situation can be where the court dismisses the petition with prejudice. With prejudice. Okay, the conclusion, actually, they can only be with prejudice. The juvenile court seems to think there's some magic in the terms, you know, without prejudice and with prejudice for purposes of appellate review and determining whether we've got an appealable order. Once you've got an adjudication, the court says, hey, we haven't got any evidence, haven't got enough evidence here, I'm dismissing the petition, boom. Of course, you know, usually that's in your favor, but not always. Maybe one of you represents the mother who wanted to see father, you know, locked up for life, you know, accused father of, you know, sexually molesting the child, for example. Where can I go with you now? Let's see here. Yes.
What about 360B?
That was my question.
360B, right. Well, there's Adam D, okay, and that's of some vintage now, but so that is the 360B is a situation where the court sustains the petition but says, you know what? I'm not going to declare the child at this point in time to be a dependent of the juvenile court. I'm going to put you on some sort of informal supervision. There's the equivalent, similar process in delinquency court, but under some informal supervision for about 6 months, and if you're real cool, you keep your cool, at the end of 6 months, the dependency case will go away. Yes, case law holds that a 360B disposition is a disposition for purposes of section 395A1 and appealable order, yes.
At the time the court finds the petition true.
Right.
Does a 360B.
Right.
It's appealable at that time.
Right. It's either Adam D or Adam S. Actually,
It's on page 7.
thank you. Is it Adam, Ms. Buell? It's Adam D, 67, so you take a look at that. So, so let's go, let's turn to our book. Let's turn to our little booklet here. Oops. Let's turn to our little booklet here. Okay, and look at some other examples of appealable orders that maybe you were unsure of. Everyone is familiar with the 60-day rule. Most likely. Is everyone familiar with the distinction between a referee and a judge for purposes of calculating the time within which to appeal? Probably not. How many referees do we have down here now?
We only have commissioners and judges.
But they, oh, X, I'm so glad you said it like that. So glad. Commissioners, Jasminder,
I
have no authority to conduct proceedings under the juvenile court law. They should not be referred to as a commissioner in the courtroom because by that office they have no authority to conduct proceedings under the juvenile court law. Do you know what gives them their authority? It's an appointment, okay? It's now Judge Nash and now Judge Levanis every year issues what's called an assignment order, and it's basically it's a list of all the commissioners, okay? And by the way, some retired bench officers that have come back into town, like Stanley Genzer, Spear, well, she's a judge. Well, so he's appointed her, so she's retired as a judge, and so he's appointed her as a referee. But anyway, these commissioners, so let's say Commissioner Deborah Losnick, okay? Commissioner Deborah Losnick holds a dual appointment as a juvenile court referee. The law provides for a juvenile court referee to conduct proceedings under the juvenile court law. In the courtroom, with all due respect and great respect for Deborah Losnick, she should be addressed, as of course as Your Honor, but as Referee Losnick. Why? That is the office by which she holds, which empowers her to conduct dependency proceedings. Okay, so back to the question of timeliness. So, what is the effect of the fact that a referee made the findings and orders which your client would like to appeal? What effect does that have? Huge effect, huge effect. Okay, so let's say, you know, you make it to judgment, make it to disposition, you got an enormous calendar, and your client says, look, look, I really need to talk to you about an appeal, and you say, look, I haven't got the time now, I've got to get back into the courtroom, but I will get back to you, and before you know it, 60 days has gone by. And you wake up in the middle of the night, and it's already 1 o'clock in the morning, you say, shit, I forgot, completely forgot. It's tomorrow will be day 61. I didn't file a notice of appeal from the judgment within 60 days for my client. That's it. I'm losing my license. No, nothing like that. Anyway, so, well, you'd be wrong, because if the orders and findings were made by Referee Losnick or any other referee in this courthouse, okay, a referee's finding, you'd have another 10 days. They have another 10 days. Oh my God, you got, oh my God, you'll think, God, I'm safe. But why? Because, okay, a referee's findings and orders do not become final for 10 days, okay, until, do not become final for 10 days until after service. When does service happen? When the juvenile court clerk here mails notice, if your client isn't present, mails notice of the referee's findings and orders, and the date of service is the date of mailing, okay? Once that, 10 days after that date of mailing of the referee's findings and orders to your client, the 60 days begins to run. So that's about 70 days. Sometimes, of course, the clerk can delay a couple of days before he or she mails notice of referee Losnick's findings and orders. But anyway, you got some breathing room there. I'm not telling you that to give you more breathing room, but if any of you are in that panic position, you've got some breathing room. If your client is present in the courtroom when the referee makes the findings and orders, probably, at least court rules haven't caught up with the statute on this, most likely that 10 days begins to run, that additional 10 days begins to run from the date that the referee made the findings and orders in the presence of your client. So for example, on May 21st, referee Losnick made the findings and orders, your client was there. Okay, I've got service on that date, but I've got 10 days after that oral service of those orders on me before my 60 days begins to run to appeal. So either way, you've got some extra time. Fascinating information, right? Oops, I'm out of the screen there again. Okay, so let's see here. Is anybody in a pickle right now? Anyone in a pickle right now with, in a quandary about, gee, when can I appeal now? Should I appeal now? Have I let something go too long? By the way, some of you have received, email communications from me. I say, hi, this is who I am, and we've got a premature notice of appeal here. And I ask you, I say, look, we got these are the options. You'll notice that I always copy a supervisor. I copy that not as a tattletale effect at all. It's just I know that we got to get moving on this right now, and I know you're super busy in the trial court, and frankly, I'm not sure. I can only imagine that your email communications must be voluminous. How many emails do you get a day? I mean, your clients all have your emails, right? God, what, do they all communicate with you by email? Huh? No, thank God. I mean, there's some restraint there on their part. Okay. All right, that's good.
Do you have any advice about when to do an application for a rehearing as opposed to an appeal? Following the appeal immediately?
Who's hearing the applications for rehearing?
You never know.
You never know, right?
A judge.
Right, a judge is, yeah, but no, there's not any one particular judge that's assigned to hear those.
It depends. Zeidler seems to have more of them than others.
Yeah, I've seen more of them with him than others. I would, from my standpoint, the more review, the better. Okay, the more if you've got an opportunity for review, and you do, of a referee's findings and orders, take it. You lose, you lose. I mean, rehearing's denied, rehearing's denied. Okay, you still got your opportunity for appeal, there's certainly no case law suggesting that the denial of an application for rehearing has any influences in any way appellate review in the Court of Appeal of the referee's findings and orders. So again, my strategy, unless you've got a complete, just junk, a junk case, you've got a junk case, but heck, and your client's insisting on review, even then I would still file the application for rehearing. one of the reasons that some of the success that is had actually on the applications for rehearing is judicial error. The judges that are reviewing the applications lose track of time or don't realize that there's a time limit. As a matter of law, if a decision, grant or deny, on that application for rehearing is not made, I think within 20 days or maybe it's 21 after the application is filed, it's deemed granted as a matter of law. So we have these little, legal quirks that result in an extra level of review. But I certainly do see the situation where, which, is, if you are going to file that application for rehearing, those are turned around, they have to be turned around again within that 20-21 day period. You've got 60 days to appeal. I do not advise filing simultaneously an application for rehearing and a notice of appeal. We do have the situations where the application is actually granted. There's a whole new rehearing, and of course that moots, that new hearing will supersede the hearing from which the notice of appeal was also filed. So the preference would be, okay, you've got a referee, file the application for rehearing. It has to be decided within 20-21 days. Mark your calendar, it's denied, great. Then file your notice of appeal. Yes?
If it's granted and you lose on the rehearing.
If it's granted and you lose, right, yeah.
On the rehearing, then
Right.
does the 60 days start running at the time the judge makes the order or the original referee?
No, no, you forget, if there's a rehearing granted, basically just forget what the referee did.
Okay.
That's gone. That's going to be superseded. Of course, it's not ever forgotten. Maybe the transcript of the hearings, of the evidence presented before the referee, but that's gone. It's superseded. So it will be from your notice of appeal will be filed. Thank you for that clarification. Right, from the orders made by the judge following rehearing. So just to no idea what time it is.
105.
105. Okay, I'm gonna jump right now using it's just a real quick segue here. What about if you got a client? You haven't got a case. You never did have a case, but you got this client that's just litigious as all get out, and file that application for rehearing, file that notice of appeal. But that kind of allows me to take a quick jump into the forbidden land of effective assistance of trial counsel. Let's not call it ineffective, let's call it effective assistance of trial counsel. If you approach situations from positive versus a negative, and we're not going to walk around here worrying about ineffective assistance of trial counsel being ineffective. We're going to walk around here focusing on being effective. And if we put our heads together as appellate and trial counsel, chances are we'll be super effective and we'll bowl over the bench before whom you folks appear every day. So, you got this client, okay, one of the classic opportunities or scenarios for a claim of ineffective assistance of counsel is that client that is just, there's no pleasingness in it, a very difficult human being, no matter what scenario that interaction with others occurs. But boy, if you've got him or her as a client, it's trouble. And chances are that kind of a client on appeal will be saying to appellate counsel, my attorney was ineffective. My attorney was very ineffective. I wanted all of these witnesses called. I told him, her, I wanted these. I gave him a list of witnesses. Wouldn't do it. On and on, right? And so I can think of one case right now. I mean, the mother prepared declarations. Her declarations of what her proposed witnesses would say, not their declarations of what they would say, but bottom line. But anyway, just a very dog with a bone type of personality. So what do you do? What's the, I remember, and actually I learned this many, many years ago from as a trial lawyer and from another trial lawyer. And believe it or not, once a long time ago, I actually used to be a deputy public defender. But anyway, so what do you do with that difficult client? How do you avoid an unpleasant entanglement with the client that can lead to the client claiming ineffective assistance of counsel? That doesn't necessarily equate with appellate counsel raising ineffective assistance of counsel. This may sound harsh, or it may sound like, whoa, I can't do that. Client says he or she's got witnesses that he or she wants to present them. Client wants that trial, hold that trial. Client wants to testify, let the client testify. In other words, now I appreciate as being formerly trial counsel and having experience in the trial court that there's a real resistance from the bench. You may encounter resistance from the judge or the referee. Wait a minute, how many units do you want to set this for? You know, what are you talking about? Wait a minute, who does this witness want to call? And county counsel say, Your Honor, we want an offer of proof on that. Wait a minute, we want an offer of proof before you call that witness to testify. Who cares? All of that's going to be on the record. All of that's going to be on the record. The record that you are making, all right, for that difficult client, okay, is that you are taking you are following, and I'm very much a fan of being the captain of the ship, believe me, but you are following the client's directives, all right, but with a greater directive in mind, in your mind, which is how to avoid a claim of ineffective assistance of trial counsel. So if you can shift, okay, a client, you've got a difficult client who is really pressing you, you can shift for purposes of review, okay, the focus from you as trial counsel and what you did or didn't do or should have done, okay, to the bench. In other words, the record, make a record that shows, wait a minute, trial counsel actually requested to call that witness. Trial counsel identified witnesses A, B, C, and D and requested to call each of them. What happened here was we don't have an ineffective assistance of counsel claim. We have a failure by the bench to a due process violation by the bench in its failure, in its refusal to permit trial counsel to present a defense, and we have obstructionist objections by county counsel, insistences on offers of proof when an offer of proof is not required by a parent at a adjudication of the petition. I mean, sure, the trial court can always ask for an offer of proof. You know, at a 2-6 hearing, okay, because the burden is yours to establish a defense determination of parental rights, the trial court will ask for an offer of proof, and it isn't good enough, stands on it, and you're out of it. But at adjudication, the burden isn't yours. Yeah, you're presenting your defense, but it's not a burden, okay? And so if you're in a trial situation at adjudication when county counsel is insisting on offer of proof, say, boom, no, the burden is yours. I have an opportunity, I have a constitutional due process right to a full and fair hearing and to defend, and boom, boom, boom. So you get the idea of how to shift the focus from you to your opponent and to the bench, and for purposes of appellate review, the focus is on their actions, not your actions or omissions. Yes.
So very clear, you know, and I think we do very well in discussing settlement with our client, they're in control of it.
Right.
Trial versus settlement, they're in control of it. Right to testify or not, they're in control of it. Now, the biggest area that we tangle all the time is when the client wants us to subpoena 35 witnesses, to which we've assessed maybe 3 are solid, and the others are not only going to make the case worse, but actually provide
Right.
evidence against our client, at what point, as we, as the attorney, have some control of the theory of the defense, as long as we can document why we're doing this.
Right.
We can discuss it with our client.
Right.
Is there interplay where we can control somewhat the theory of the defense with the client's right to a trial?
As a general rule, case law, boom, backs you up 100%. You as trial counsel are captain of the ship, period. You have control over how that case is presented, with one exception, right to testify. Okay, that's the only one. So you can pull that card. You could pull that card on your client, okay? I'm saying, though, don't pull it. In the situation, call their bluff. And believe me, I have represented criminal defendants. But anyway, call the bluff. In other words, you've got 30, I've looked at 3, you've got 30 more, you've got 32 more witnesses. You want me to subpoena? Get the subpoenas out. Get the dang subpoenas out. Chances are, okay, 28 of those individuals aren't going to be found, okay? Why not? Now, maybe you're getting pushback from the bench. I can understand maybe you're getting pushback just from your own trial resources, you know, time, caseload at LADL. You know, it could save you a lot of anguish in the long run. But I don't want to overrule your supervisors here. So obviously you're going to talk this over with them, you know, don't say Stephanie Miller said subpoena all of them, but, you know, but I'm saying that it might be the easier way out in the long run. And the less oppositional, yeah. That's what I say. Well, I know it's 1:13. I mean, I can really literally go on for hours. There's such a tremendous amount of material to cover. So what would you like me to do, folks? We can, let's see here. Well, nobody's getting up, leaving, so let's see, you know, let's see here. So,
Questions?
yes. Oh, yes, of course, questions. So sorry.
Sometimes we get requests for minute orders.
Yeah. Oh, you know what? It's the turkey heads. Look, this is the situation. Okay. All right. The juvenile court clerk's office is supposed to provide, ever since we came in with the new administration in 2015, you know, you get a new administration in. Ever seen that happen in Washington, D.C.? And everybody thinks they know how to do it better than the guy before, and all hell breaks loose, and you haven't got adequate staffing, and frankly, nobody knows what the hell they're doing. Anyway, so we used to routinely, before 2015, boy, because there's a rule of court that says we get that minute order for any post-notice of appeal hearing. Why? Because, of course, there are developments that are going on in the juvenile court while the appeal is pending. Okay, you've always got to keep your eye on the ball in both courts. Anyway, that could moot the appeal, all right? So, anyway, unfortunately, under the new administration, the clerk's office stopped doing that. Nah, we don't have to do that. Anyway, so I routinely, and again, as recently as 2 days ago, and at seminars, instruct appellate counsel, contact the staff attorney at the California Appellate Project that's assigned to your case. He or she, I will request the minute order and get it for you. So don't, look, if you just happen to have a free afternoon and can get a minute order, you know, out of the goodness of your heart, hallelujah. But basically, tell them, you know what? Stephanie Miller said, call Cap LA. That's enough of that crap. I mean, that's just, it really just blows my mind. It takes forever to get through on stuff like this. What is your name, though? Sorry.
Carolina.
Oh, that's Carolina Villamil.
That's me.
Right. Carolina Villamil. And I forgot to ask your name.
Amy Einstein.
Right, Amy Einstein. How are you? It's so nice to see you.
Hi.
I had a.
Who are you, though?
Oh, I'm Kim Kopaka.
Kim, hi.
Hi.
Marvelous. Okay, great.
I had a call from an appellate attorney where I have a pending jurisdictional and dispositional finding.
Mhm.
We had a 2-1E coming up, and she told me that I needed to make sure I continued to lodge an objection to the adjudication and
Right.
dispositional
I think I
finding.
got that call, too.
Okay.
Try to straighten that attorney out. Yeah, right.
Uh,
Okay, this is a concern. All right, this is a concern. There's a case And you know, I think it's beyond the 2/11 date on my forfeiture. I think it's Danny, Danny C. Anyway, this is what happened. Appeal, got a pending appeal from the judgment, all right? And 6-month review, and you know, the brief's written, and it's like, okay, you know, we're challenging the true findings on the petition and the removal order, right? So that's all briefed, and 6-month review hearing comes along, and trial counsel goes into the courtroom and says, we submit on the social study, Your Honor, and we agree that you know the conditions that justified jurisdiction in the first instance continue to exist. Well, of course, the Court of Appeal got a hold of that minute order in which trial counsel said all that, and that course completely forfeited, waived, and eliminated the appeal. So appellate counsel, who don't quite appreciate the nuances there, I'm trying to remember who the attorney is, because I'm sure we're talking about the same individual, but anyway, called you and said, oh my God, you know, you got the 6-month review hearing, you need to object again to to jurisdiction having been taken in the first instance. No. Just don't say, hey, you know what, you were perfectly right to take jurisdiction in the first instance. Yeah. So I think I made that clear to appellate counsel. It's fascinating. You know, it really is. The art of communication is truly an art, and I'm not good at it. It's just amazing how things can, you know, come out or be understood or registered by, you know, the human mind. Yes, Jennifer?
Yes, as a follow-up to that, what if the recommendation on the 2-1E is to continue FR? Can you submit on that recommendation?
No, yeah, fantastic. Yeah, we're happy. Yeah, God, we want, you know, if the alternative, of course, look, okay, if you go into the 2-1E and say, done everything, jam up jelly tight here, no substantial, you know, risk of harm if you return. I've done all the parenting. In fact, I did 52 weeks of domestic violence courses, and 26, you know, I'm together, all right? What you're going to be objecting to is the finding that, no substantial, there's no substantial risk left here, give me the kid back. So, but no, okay, let's say this, I can give you an example, but again, this is probably a post 2011 case. I think it's Jennifer S. or Jennifer V. Damn. Anyway, situation is this. Your parent is fighting those true findings, fighting the petition allegations, loses, we get to disposition, and, the parent, objects to removal, oh gosh, doesn't want that to happen, but says, look, okay, if you're going to remove, place the child with Auntie Susie. Okay, well, respondent argued on appeal, you can't challenge removal, you agreed to placement. No. That agreement, in other words, so the reviewing courts in that situation, as it would in your situation, you're at the 2-1E, you're not going to get the kid back, but hey, at least the court isn't terminating reunification services, it's continuing them. That's strategy. You're protecting what interests your client has left in the ballgame, and that's not going to be construed as a waiver of your challenge to the judgment. Anyone else want to?
I just have one
yes,
more.
Yes.
So are there any circumstances in which we have to note an ongoing objection at every subsequent hearing? Because that half attorney that Kim talked about is not the only one who makes that request.
Yeah, they're wrong. Don't worry. We're gonna have a seminar. I'll do another seminar on January 19th. It's like, I think. Gosh, I think, God bless her, Mary Ann Good is probably one individual. Who else? Don't worry. Don't worry. We're all, we got to get this figured out, guys. It's not bad-mouthing anybody. It's just reality, so everybody understands what's expected of the other in this ball game, so we can do a good job. We can do a good job. I can't think of one.
So I was told, if county council says something, I argue back, we go back and forth, we're arguing left and right, and then the judge makes a ruling. I admit, Your Honor, I
Yay! Finally! Yes! That has been accepted.
That is.
I thought, why wasn't the work next to 3?